and that there may have been, after this meeting, at least her impression that she may have been able to stay. And I don't know. Does she not know what the allegations are based after the meeting? Whether she agrees with them or not? Because one of the things that she said was it didn't happen. Or calls the case of New Park Ridge versus Takema Cooper.
Lou Maskell here for Ms. Cooper.
All right, this is your motion.
It is, Your Honor. We are here on my client's motion for summary disposition. If the court is ready, we can proceed with the argument.
Go ahead.
So it's our position that the notice that was provided to my client was vague and therefore didn't meet the statutory requirements and cannot be relied upon to confer subject matter jurisdiction to the court. Specifically under the HUD regulations, the state requirements found in MCL 600-5716, and even the lease itself requires that the termination notice must state the grounds for termination in enough detail for my client to prepare a defense. The notice itself merely says that there were physical threats and verbal abuse to property management staff. It doesn't cite the lease provisions that they're relying on. And as the court is aware,
But what's the requirement for the notice to state that?
what's the requirement for the notice to state?
The lease provisions or whatever. I mean, because statutorily, because of the physical threats, they could file a notice to quit.
Well, Your Honor, they have to plead with, or they have to, in the notice, put enough detail in there so that the client can prepare a defense. And that would include, you know, who was involved with the incidents, when they took place, where they took place, what was alleged to have happened.
In the notice?
In the notice. There's a higher standard for notice pleadings in subsidized housing than compared to private housing.
Right, but did she take advantage of the meeting?
She did have a meeting.
Okay, was that laid out? And that was prior to the filing of the complaint?
That's correct, Your Honor.
And were the details regarding what was complained of the physical threats discussed in the meeting?
The physical threats didn't happen, so that's why.
Well, I'm not.
I mean, question, but we had the meeting 5 days later, and
I think my client was certainly confused at the end of the meeting as to what was being alleged against her. And she, at the end of the meeting, also felt that, or was her impression that they were allowing her to stay, and was surprised by the fact that they had filed a case against her. By the end of the meeting, that was her impression that, you know, I think they said, well, if you get your ducks in a row, you can stay, something to that effect. She believed that she was going to be able to continue to live there.
Mr. Frank?
So
Go ahead. I'm sorry, Ms. Maskell. Go ahead.
the other issue with the notice, Your Honor, is that they haven't specified in the lease, you know, what lease provisions or what standard they're adhering to terminate the lease. So, you know, if you refer to the lease, it says that they can only terminate in certain circumstances. One of those is material noncompliance with the lease. Another category would be good cause, and those are found in paragraph 22 of the lease. And good cause is also defined in several different ways in the lease. So they don't specify what exactly provision of the lease they're relying on, merely just saying that there were allegedly, you know, some threats made. So it's our position really that they don't comply with federal or state laws about notice requirements in subsidized housing, or even the lease itself.
Your Honor, I just have three things to say. The first is that even if what my sister at the bar alleged was accurate in terms of facts, that would not deny this court subject matter jurisdiction. That's the sole basis for this motion, 0.116C4, that you lack subject matter jurisdiction. We have litigated this issue before, albeit in a CARES Act case, but it's the same thing. We filed a complaint with a notice to quit and a copy of the lease pursuant to the statute, you have subject matter jurisdiction over summary proceedings. That's the first part. Secondly, the complaint itself alleges a violation of lease paragraph 12 and 22 and references the notice to quit. And third, if the defendant would like a more definite statement, you can order us to provide one and we will lay it out. Those are my three responses, Judge. I don't think I have anything else to say.
Anything else?
Yes, Your Honor, with regard to Mr. Fink's last point first, the reason that the notice itself has to include more specific details is it provides the tenants with an opportunity to decide how they want to proceed. Specifically, she may have decided to move out. She may have decided to, seek other arrangements. It's not appropriate to leave that all until a trial to take place before she can learn what the actual accusations are against her.
But isn't that the reason really for the meeting?
It's the law requires it to be in writing, Your Honor. The meeting is a chance to discuss the terms, but she didn't even know what she was walking in to discuss when she came into the meeting, really, because it wasn't spelled out for her. The second issue I want to address, Your Honor, is the subject matter jurisdiction. Ypsilanti Housing Commission versus O'Day specifically states that if the notice itself doesn't comply with statutory requirements, that it's invalid. And then you couple that with Park Forest, and which says that you need a proper termination notice in order to have jurisdiction or hear a case. So those two cases together, the notice is improper. You don't have a proper notice. You don't have subject matter jurisdiction to hear the case. That's our position on the subject matter issue.
You're saying in O'Day it said what? I mean, I remember O'Day because I litigated it, but go ahead.
They found that there wasn't a proper notice in that case and that they were required to adhere to.
But the reason for the notice being improper was?
I mean, in that case, in that case, there was the 7-day versus the 30-day notice, right? And so they gave a 7-day notice, which I think was provided for in their lease, which didn't comply with the state statute.
Which didn't comply with the state statute regarding, but complied with HUD regulations.
Right, which
then taught everybody to comply with state statutes and not HUD regulations, which this notice in this case complies with the state regulations.
I disagree, Your Honor, that it complies with the state or with the lease. So even if you find that it complies with the HUD regulations, I would say it still doesn't meet.
I mean, if the basis upon which you're saying that this court doesn't get jurisdiction and that the notice for that reason is improper, I think that the notice is proper. If the notice has to state certain things, it does that. To the extent that there is some, I guess, penalty or something that might adhere to or near to your client regarding this, I don't think that happens in this case. I mean, the 10 days to discuss it with management, she had those 10 days. I don't know what came out of the meeting. I typically don't know what comes out of the meeting, but they typically do that before such time as they do it. But as far as the particular provisions of the state and the conferring of jurisdiction on this court, I believe that the notice is satisfactory in terms of complying or conferring upon this court notice. I just will say one thing. It's April 1st. So I'm going to deny your motion for summary disposition on those grounds. Now that there's a case before me, I guess I am a bit concerned as to at least what your client has indicated, that she's not sure of what the allegations are. And that there may have been, after this meeting, at least her impression that she may have been able to stay. And I don't know. Does she not know what the allegations are based after the meeting? Whether she agrees with them or not. Because one of the things that she said was, it didn't happen. Okay, well, that may have to be litigated as to whether or not it happened or not, but
Your Honor, I don't know what the allegations are, so I haven't been able to go over that with my client to answer your
Okay.
question.
Right. Okay.
Your Honor, what if we did a final settlement conference? That we give all of us a chance to be at the same place at the same time, and in the meantime, I will get as much information as I can and forward it to Ms. Maskell.
Well, I think, yeah, I don't have a problem structurally with that, but I think there needs to be something more definite so that counsel can sit down with her client. It used to be at those meetings that there was something written that came out of it. I don't know that that was ever required, but I certainly Ann Arbor
I
House
think
can-
there was something, but I was focused on this motion and the one reason for it, but are you ordering us to provide a more definite statement?
Yes,
By when?
with specifics in that. Guess I would like to see that before the end of the month, by the 28th. Can you do that? Well, you need more time than that?
Oh, Your Honor, I have an intern who is looking for substantive work to do and wants to impress you. So the 28th is fine.
Well, we'll
He's
see.
smiling, so
We'll see if the latter will happen. So you can get that to Ms. Maskell so that she can sit down with her client. I
and
guess,
then we'll do a final settlement. I don't need a response from Ms. Maskell to the more definite statement. I'm not saying she
well,
can't file one.
I am certainly she can, but I realize that if there is an issue, the two of you will talk. It's the parties that don't talk that bother me. So I'm sure there will be discussion that will go back and forth. And so if there's a necessity for you to file a response, certainly
Okay,
you can, Ms. Maskell.
thank you.
But what I then want to do is make sure that there's enough time for Ms. Maskell to do any investigation that she might need to do regarding those allegations, because she couldn't have a meaningful discussion either with the client or with you, Mr. Fink. So I would probably move it into the latter part of July,
Like the 22nd.
23rd. Why do you keep picking
23rd.
dates? The 23rd, that's a Tuesday. Did he ask you or he just started?
Oh, Your Honor, I always ask, even when it doesn't sound like it.
Yeah. Okay.
What's going to be scheduled for that day, Your Honor?
I was going to set a final settlement conference for that day. If that is enough, what I was trying to lay out, Ms. Maskell, was if they get that to you by the 28th, you'd be able to have preliminary discussions, figure out exactly what it is, give you enough time to kind of at least do the preliminary part of any investigation into what the allegations are. And then I would have a final settlement conference on the 23rd of July.
I think
We'll work it
council
out.
has been willing generally to comply with any discovery requests.
Generally,
That potentially and very likely there will be some discovery that's necessary after we get that 28th document. So that's my only
right. And
thought about timing.
here's what I also want to know. Is there a police report? Is there any outside agency that would have responded to any of this?
Not that we're aware of, Your Honor.
Mr. Fink?
I do not know.
Got it. Okay, that's fair.
I'll do a short order that says the motion for summary is denied, that we're to provide a more definite statement by 6/28, and the parties are to appear on 7/23 at
9 in person.
for a final settlement conference.
Your Honor, one other issue.
Oh,
There
yes.
are a few outstanding maintenance requests. I believe I spoke with Jillian about it. I can forward those along to you. I'm asking that we work together to get those
You want him to do them?
addressed. I would love for you to do them, Your Honor.
He's pretty handy.
I would.
Oh,
absolutely trust
no.
your hand. I expect that is not. I
That's
just
what it
have to
is.
look at the code.
Plumbing and electrical I can do,
You
but
send them to Ms. Engen, we'll make sure they get to
Okay.
the client.
okay.
We're good. Thank you, Your Honor.
All righty. Thank you.
14A District Court for County of Michigan is now back in session. The honorable.
All right. Okay. In the Lee versus Fond matter.
James, thank you, plaintiff.
Gail Rosen on behalf of the defendants.
and also Thomas Miller. Daniel. What we have, we've had a we've had a settlement conference. I think we've resolved some issues. And coming back, this matter may have to proceed a little bit further. But the court's understanding is that the plaintiff will provide extermination services to the unit within the next week and a half, somewhere around there. The utilities, the divide of the utilities still has to be decided. I have noted for the defendants that although the lease would allow it to happen, the plaintiff hasn't been charging for water or Wi-Fi. There's an agreement between the parties that rent beginning July will be adjusted to the $1,500 per month. And then a decision will be made as to what the rent on it will be, is the amount that will need to be placed into escrow beginning in July. There is the possibility the court reserves the right to release a portion of the escrow to the plaintiff to be able to maintain care of the property. The defendant will be placing into escrow May's rent and the estimated, or actually maybe actual utilities of $564, basically to date, I guess, at least as to billing. And
By what date, Your Honor?
by
What date should they place it in escrow?
how soon can they do that? Within a week, can you do that?
Thank you.
And then the only other issue that I have here is that the defendant has agreed to move I guess it's the garbage can off of the grass and put it on another surface. That's all that I have, counsel.
Your Honor, I am going to send an email to the attorney representing Ann Arbor Township. I'll copy Ms. Weidling and Ms. Rosen, giving a summary that we've all agreed we'd like them to stand down until the defendants have an opportunity to move out.
Okay, very good.
Thank you for your time, Your Honor.
Not a problem. And
In order.
yes, if we could.
We'll take care of it.
Okay. That's you, but
I'll do it.
Wait, he's looking at me. You do it?
Yeah.
he's gonna draft the order. Mr. Fink is doing orders all over the place because he doesn't have. All right, and we'll kick this out to July 23rd, 2024 at 9 a.m. And court does call the case of Hamilton Crossing versus Tiffany Peters.
Okay, take the plaintiff.
I have before me an emergency order to stay.
Yes, Your Honor, and I'm asking, I don't know if we need it now that we're getting here. We're the other part of my motion was to set aside a default judgment.
Yes.
So I'm just gonna argue that.
Okay, that's fine.
Your Honor, Ms. Peterson did not appear for the hearing on April 12th because in between the complaint being filed on, I believe, March 12th and the date that the March 11th, I'm sorry, Your Honor, and the date that the default judgment was entered, she was offered a last chance letter by the landlord that they both signed on March 28th. So she thought the issue was resolved, and that's why she didn't appear. And I have a copy of that for Your Honor if you'd like to look at it.
Last chance agreement. I thought it was included. I know I read that.
Yes, I did attach it. to my
The motion, yes. I think I saw it. All right. Okay.
And so that's why she did not appear. And then as far as
That was on the 29th. Was that the day you actually signed it?
It appears to have been signed on the 28th of March.
March. Okay.
And Your Honor, additionally, Ms. Peterson does have significant mental health issues. And so, even though I think it's fairly reasonable for her to assume that she doesn't need to appear in court anymore on the witness case after this has been signed, I think she was also confused about if she did need, that was not clear to her.
Mr. Fink.
Your Honor, they signed the last chance agreement on the 28th. On the 29th, we had court and the case, and Ms. Peterson appeared, and the case was adjourned to the 12th for the purpose of setting out a COD with the court. And we prepared one. And by the way, the COD would have included a provision that she moved by May 1st, but she didn't sign the COD and she didn't come to court. And so she was told after she signed the last chance agreement, she needed to come back to court and that there would be a COD. And she didn't show up for court. And so we took a default judgment. 8 weeks later, this motion is filed, 56 days. And while my client is always willing to give a soft landing, and we can probably work something out on the writ date, there has not been good cause nor a meritorious defense to the case established that would require, or I won't say allow because I know better, but would prompt the court to set aside the default judgment.
And I have, the reason that I waited to file is because I monitored the court to see if a writ was filed, because Ms. Peterson, I connected her with SOS Relocation Services, and they've been just working on finding her a new place. But what happened is she and Grace at SOS thought that Ms. Peterson had a voucher for a 3-bedroom. And then when they got down to the end of the process, they found out that she only has a voucher for a 2-bedroom. So they had to start over. And then we had to get her voucher extended and all of that. So she is willing to move, but I just don't want there to be a time of the opposite of overlap where she and her 2 kids are unhoused, even though she, has a voucher and is willing to move. And I will say also that the incident that caused all of this to happen was in December. And in the interim, she's been court ordered to be medicated, and she is very, I've seen her when she's not medicated, and I've seen her when she is, and she's very different now that she's medicated, and she is able to make good decisions and such. So she hasn't, they did offer her a last chance letter, and she has complied with it. I don't know the purpose of offering this the day before a court hearing where they still want to evict her. And I don't know that she understood the inner workings of how all of that was going to fit together. And even if she understood it when she was here, I know that from working with her that she gets confused. And she missed, I'm sorry, one more thing. There was another court date that she missed around the same time as the second court date here. So I think she may have been having a difficult couple of days in tracking her responsibilities.
In the last I knew about that other court date, that was the criminal case for the event that caused her to receive the notice to quit. The last time I checked, and I'm not saying this is true now, but the last time I checked, she had failed to appear and there was a warrant out of 14-2.
And I brought that to her attention, and I believe that she called the court to clear the warrant.
Did you get that taken care of, ma'am, or? Okay, all right, listen.
I go to chiropractor every 3 days on the week. I take medication. I have 2 young boys that I have to tend to.
Okay, listen. Okay, hang on a second. When you leave here, go right next door to the public. Were you represented by the public defender's office at your court hearing? Do you know?
When for this,
No, for
I
the,
didn't even know nothing about it. I
Okay,
just-
okay,
I didn't
okay.
know I had it.
okay. Do this. You see anything?
At 14A2, she failed to appear for the arraignment retrial, so she's not yet represented.
Okay, she can still probably get help from them. So I'd ask you to stop next door out here. That's the public defender's office.
Okay.
Tell them I sent you there, that you got a warrant out of 14-2 in Ipsy. Okay. And that you need some help getting that clear. Okay, because what I don't want to have happen is I understand you got a lot of stuff. I don't want you getting arrested on that. Okay, so you need you to do that. They're just right next to the this court. Okay. What I'm inclined to do on this case, counsel, do you think that a move out date can be worked out for your client? Where with the voucher process the way you have it now?
I just found out this morning that they extended her voucher to June 30th, which is really tight. What I was gonna ask Mr. Fink for was to just work with us as long as she diligently works with SOS to relocate, just let that process play out. But if she can't be out by July 1st, to not evict her. And I'm in contact with SOS on almost a daily basis.
So they've extended her to June
30th.
June 30th. Is it right? Oh, okay. So
Finish that half.
got it. When's my next? Not the 23rd. 16th. All right. Let me adjourn this out to the 16th of July.
Thank you, Your Honor.
Your Honor, is the order of eviction in the hands of the process server?
It is not. I did not sign.
July 3rd, is that what I heard?
July 16th,
July 16th.
2024. All right.
Yes, I'm available that day.
All right. Real good. So thank you, folks.
Thank you, Your Honor.
Thank you.
Have to run because.
All right. Ma'am, did you, what is that? Oh, ma'am, we just printed you out the ROA, our case management system. So when you go next door, show them that, tell them you got a warrant, you need help getting it cleared. Okay, and if you have to, tell them that Judge Simpson sent you over. Thank you.
All rise. 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge J. Cedric Simpson presiding.
You may be seated. So are they back yet? Nah, probably not. Okay. Are you guys ready on? Looks like Miss Maskell.
Ready, Your Honor.
She's all packed up and ready to roll.
My client just stepped out to get the other.
Which is your,
She'll be right. I'll grab her.
okay. Let me start with this one. Monica King versus Sarah Goebel.
You think the plaintiff?
Sarah Goebel,
Oh,
your name, ma'am?
sorry, sir. It is Sarah Gold.
All right. And where are we on this case?
Your Honor, I know the court's familiar with both the situation and the case because you dismissed a prior case in terms of the non-payment claim. The rent now due is $4,800. The costs are $258 for a total of $5,058. But we amended our complaint to include a termination of tenancy case. And in neither circumstance is there a triable issue.
So yesterday I did apply for our DHS assistance, so I can at least try to get some state. I do not owe all of that, Your Honor. I did say that last time. I'm gonna state that again. All of this started over her assault to me and me calling the police. This is the whole reason why this situation started. I am looking to move and I am going to move. I just kind of want to make sure that all of this is taken care of. I don't feel safe living in her home anymore. She's
All right,
now, since
so-
it started, she's now shut off the Wi-Fi, which was supposed to be included in the rent. She is shut off she shut the fuse off downstairs to the washer and dryer, so I no longer come to the washer and dryer. She has taken the lock off the spring door, so I can no longer lock the spring door.
Judge, are we trying this case now?
I don't know what we're doing. Ma'am, but you want to move out.
I do want to look to move out, so I am asking that DHS help me, get this paid, so that way I don't owe any money. I don't.
Well, this is a possession only case. I don't, they're not asking for a money judgment at this
Oh,
time.
I thought they. I thought that's.
So it's just a possession only case. So when are you going to move?
By July 1st. Really, probably.
Today's what, the 18th? Okay.
Your Honor, the 10 days would be the 28th. I think the first, I think it's a Monday. Is that right?
First is a Monday.
So if we have a judgment with no redemption amount for the 28th and she's gone by the 1st, she will have satisfied the judgment.
Why?
I have no idea what any of that means. Sorry.
Basically, there would be a judgment. There's nothing in this case for me to try. So first of all, so there would be a judgment. You want to move.
Yes.
They're not asking at this time for money. So it would just be fashioning a judgment for a move out date. And and you would normally get 10 days.
Okay.
You said July 1st, you would normally get 10 days. I would make it the 28th, which would be 10 days, but that's a Friday. And so the 1st is that Monday.
Okay, sounds good to me.
Does it work?
Yeah.
Okay. Court,
Your Honor, I have
after
a,
hearing, no tribal issue?
and I'll take out the redemption amount.
Correct. There'll be no redemption amount. We'll just do it as a termination. You'll move. That sound good?
Yes, sir. Thank you.
All right.
Doesn't, then what? I have to come
Well,
back.
hold on. Well, hold on.
Oh, she,
Hold on. We're not quite done.
We get an order of eviction.
so then I have to come back.
Okay. So ma'am, the judgment here in front of me, they're not going to put a redemption date. So basically it just means you're going to move. And that you're going to move by June 28th, 2024, which would be your 10 days. And I'm finding that based after a hearing on no tribal issue. Any questions you have?
So with them saying that I owe this money though, what is that really?
They would have to bring another claim if they're claiming that you owe money.
Okay,
But that's not, right now, that's not before me.
okay. And then the other question would be, with this being an eviction, is this an eviction so that it'll go on my record? Is that correct?
It would, it would. I hate when people say their record, but what will happen is that it will show that there was a judgment entered
And
for
then
possession.
My question is, with her stating that there's all these other people in the home, is it gonna go, because that's my mother-in-law, my brother-in-law that don't live there, none of them live there, my husband, is that gonna go on them too, as well?
Well, the people that I have in the case are Sarah and Donald Goble
Mm-hmm.
and Joshua Goble.
Yeah.
And Gladys Down.
Yeah, and that's what I don't understand, is why she has all these people that live in my home.
Are
She
they,
did that.
are they in the premises?
No, sir, they were my guests here and there. That's my mother-in-law.
Your
I don't know
Honor,
how she got their
they,
names.
they have each been there at some time or another. Each has,
As
inter-
my guests.
ma'am, each has interacted with Ms. Goble. None of them has appeared in this court. We could make it a default judgment. If they want to ask for relief from judgment at some later point, we could discuss it, but each of them has been there, and I didn't want to be in a position where I had a judgment against Ms. Goble and someone else claimed possession. And so that's why I named them as defendants. They certainly knew about it, and at least one of them had a conversation with Ms. King about it, but we named them as defendants. If you want to make it by default for everyone except Sarah Goebbels, that's fine. Just want possession. And in response to her question, which you answered fine, but I'll just add that if she moves, we don't get an order of eviction.
That's right.
So again, if I'm.
Here's what I'm gonna do. They have not appeared. Okay, so it's gonna have the same net effect, but I'm gonna issue the judgment by default as to defendants 2, 3, 4.
Thank you.
And after a hearing, finding no tribal issue as to you. So if they And I realize you might be sticking up for them, but if they want to do something about that, they'll have to file a motion with the court to get rid of it. Okay?
Yeah, because we do plan on doing some, but that's afterwards.
All right. Very good. I've signed it. Thank you.
Thank you, sir. Have a good day.
You do the same. Lee versus Bevan. Are they, there's Mr. Fink, where's Miss Rosen? Oh, there she is back there hiding from me. Okay, hold on one moment. Was anybody able to find Miss,
Bauer is in the outside conference room, Your Honor, waiting for her case to be called in Judge Barr's courtroom. By Zoom.
pardon? Can you do what? Who are you? I think she is representing you.
And I've been here all since this morning.
And so what would you like me to do? Well, I'm looking at you, but you mean call your case?
Yes, sir.
You have an attorney.
Yes, but
It would be unethical for me. It would be unethical for me to call the case when I know you have an attorney. You know what? You can go out there and tell Miss Bauer, go out there, tell Miss Bauer that you fired him, then you come back in and you can represent yourself. As soon as she lets me know. Court's going to stand in brief recess. I'll come out and deal with Ms. Rose and Mr. Fink. I will deal with you in a moment. You don't want to deal with me right this second. Court stand in recess.
All rise.